It was 8:43 a.m. on a Wednesday when I realized I was about to end a man's career. Case number CR 19482 was stamped at the top of the file, State v. Harris. Simple label. Nothing simple about what happened next. I've been on this bench for 22 years. In that time, I've watched people lie, break, confess, heal, and self-destruct, all under the same fluorescent lights. If you took a dozen real days from my courtroom and stitched them together, you'd get a dramatized story a lot like this one. Different names, same choices. And on this particular morning, the choice belonged to a uniformed officer who looked me in the eye and refused a direct order on the record. He thought the badge on his chest would protect him. It didn't. Because in my courtroom, the law wears the robe, not the uniform, and that's when everything changed. Courtroom 4B in Riverton County is not glamorous. Beige walls, worn oak benches, the faint smell of burnt coffee from a pot that should have been retired during the last administration. The digital clock above the doors blinked 8:43 in harsh red numbers. The defendant, Jamal Harris, 23, sat at the defense table in an oversized navy blazer that didn't quite fit his shoulders, charged with resisting arrest and assault on a peace officer. According to the charging document, he'd lunged at an officer during a traffic stop and attempted to seize the officer's weapon. I've learned to listen very carefully when the word lunged appears in a police report. It's vague, elastic. It can mean anything from took a step to actually attacked. At the other table sat the officer, Officer Mark Rios, 12-year veteran of the Riverton Police Department, navy dress uniform, polished badge, short-cropped hair. His posture was perfect, too perfect. Back straight, hands folded, eyes locked on a point just above my head, like he was staring at the flag instead of the human being in front of him. I had seen Rios before, on paper and in person. He was one of those names that appeared regularly on arrest affidavits in certain neighborhoods. Commendations, use of force reports, disciplinary notes. The file was thick, the gallery was full, law students in the back row, a couple of off-duty officers, and on the left side, a young woman clutching her phone so tightly her knuckles were white. I'd later learned she was Jamal's sister. The state's attorney, Miller, straightened his tie and nodded at me. The defense attorney, Ruiz, shuffled her color-coded folders. The court reporter adjusted her headphones. Routine, predictable, right up until it wasn't. I tapped my pen once against the mahogany and called the case. On the record in State v. Harris, cause number CR 19482, appearances for the record. Voices followed in order as they always do. Matthew Miller for the state, Your Honor. Maria Ruiz for Mr. Harris, who is present and seated to my left, Your Honor. Officer Mark A. Rios, badge number 714, present as complaining witness, Your Honor. I looked first at Jamal. He kept his eyes down, jaw tight. The kind of young man who had learned that looking at authority too long could be taken as a challenge. Sweat beaded at his temple despite the cool air. I'd read his file. Minor priors, trespass, a shoplifting incident as a juvenile. Nothing violent, nothing that matched attempting to seize a weapon. Then I looked at Rios. He met my gaze, expression unreadable, but his right thumb tapped the side of his index finger, a small repetitive movement. That's the detail I remember, not the crisp uniform, not the shine of the badge, just that little nervous rhythm, like a drummer who can't find the beat. I'd seen that too. It's what people do when they're ready for a fight, but not for the truth. Counsel, I said, I've reviewed the probable cause affidavit. This morning we're here on the defense motion to dismiss and the motion to compel production of full body-worn camera footage. Is that correct? Yes, Your Honor, Ruiz answered, and we'll be calling Officer Rios. Very well, I said. Let's begin. Nobody in that room knew it yet, but by the time we were done, the young man in the navy blazer would be walking out of my courtroom free, and the man in uniform would be walking out with a career that was effectively over. The clerk swore in Officer Rios. He raised his right hand, voice steady. Do you swear or affirm the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. He took the stand. Miller started with direct examination. It was textbook. Officer, directing your attention to the night of March 15th, 8:17 p.m. Were you on duty? Yes, sir. What was your assignment? Traffic enforcement along Lincoln Avenue. His answers came smoothly. He described the stop, Jamal's car, a broken taillight, strong odor of marijuana, Jamal acting agitated, refusing commands. And what happened when you asked the defendant to step out of the vehicle? He lunged toward my firearm, Your Honor, Rios said, turning slightly toward me. I feared for my safety. There it was, lunged again. And what did you do then? Miller asked. I executed a standard armbar takedown, placed him on the ground, and secured him. Did the defendant strike you? He struck my chest with his open hand as he reached for my weapon, Rios said. I felt contact. I believed he was attempting to grab it. The words were clean, rehearsed, too clean. And is this a fair and accurate description of what occurred? Yes, sir. Miller sat down. Ruiz stood. Defense attorneys walk a tightrope in cross-examining officers. Push too hard, and you risk alienating jurors or the bench. Go too soft, and your client pays the price. Ruiz knew how to walk it. Good morning, Officer Rios. Good morning. You've been with Riverton PD 12 years? That's correct. You've written, let's see. She flipped a page. More than 800 incident reports? Yes, ma'am. You know how to document an event. I do. In your report, you wrote, quote, defendant lunged toward my firearm, correct? Yes. You did not write attempted to seize, did you? No. You did not write grabbed or pulled? No. You wrote lunged. Yes. She walked slowly to the evidence screen. And you were wearing a body-worn camera that night? Yes. Department policy requires it to remain activated during all citizen contacts, correct? Correct. Did you deactivate it at any point? No, ma'am. She nodded. And yet the state has produced only a 42-second clip that begins after Mr. Harris is already on the ground. You'd agree with me that the initial contact is not on the recording we have, Miller objected. Objection misstates the evidence. We produced what we received from the department. Overruled, I said. You may answer. Rios shifted. There was a technical issue, Your Honor. The camera malfunctioned. What happened next, I remember thinking, would make the whole courtroom go silent. Officer, Ruiz said, who controls the upload of your camera footage? The system does it automatically at the end of my shift. Do you have the ability to manually tag or redact segments? Within policy, yes. Did you do so in this case? No. She let the silence hang. Then she turned to me. Your Honor, at this time, pursuant to our motion to compel, we're asking the court to order full production of all unedited body-worn camera footage from that night, including metadata, as well as any dash cam from nearby units. We believe what's missing is instructive. Miller stood. We've produced all we have, Your Honor. We're not IT technicians. I'd already read the memo from the department, partial file corrupted. No further detail. That kind of vagueness makes me itch. I leaned forward. Officer Rios, I said, as of this moment, do you have any reason to believe additional footage exists that has not been produced to this court? He hesitated, just for a second, but in a courtroom, a second is a lifetime. No, Your Honor, he said. That's when Ruiz played her hand. Your Honor, she said, my investigator served a subpoena on the city's IT vendor last week. This morning at 8:02 a.m., we received a response. Attached was a hash log showing a 3-minute and 12-second file uploaded from badge 714 the night of March 15th at 21:03 hours. She held up a stapled packet. The state has given us 42 seconds. The gallery murmured. Someone in the back exhaled sharply. And that's when everything changed. I took the packet, scanned the timestamp. 21:03 hours, 3 minutes, 12 seconds. File designation, BW7140315. Status, deleted by user, archive retained. Deleted by user. I looked up at Rios. His thumb was tapping faster now. Officer, I asked quietly, did you delete any body-worn camera footage related to this incident? His jaw flexed. On advice of counsel, I respectfully declined to answer that question, Your Honor. You could feel the air shift. He had every right to assert his Fifth Amendment privilege. But there are prices to those choices. Moments like this, when a simple file name changes the entire shape of a case, are why I tell these stories. They're dramatized composites, but the decisions are painfully real. If you want to sit in the gallery with me for more days like this, you're welcome to stay, subscribe, and keep listening. Now let me tell you what that deleted file cost him. When an officer hides evidence, it doesn't just stain their own name, it seeps into every case they've ever touched. Counsel, I said, approach. We went off the record for a brief bench conference, then back on. For the record, I said, the court has reviewed Defense Exhibit 4, the vendor log correlating with Officer Rios's body-worn camera. There is a discrepancy between what exists on the vendor's archive and what has been provided in discovery. I paused. Officer Rios, please step down from the witness stand and stand before the bench. He walked forward, every eye following him. He looked suddenly smaller, even in that crisp uniform. "Officer," I said, "I am ordering you to do 3 things. First, you are to execute a release authorizing the vendor to provide this court with the full archived footage from your camera for the night in question. Second, you are to produce today your patrol vehicle's dashcam logs for that shift. Third, you are to surrender your phone to the department's Internal Affairs Unit for forensic imaging, limited to communications about this case." His attorney, department counsel, had joined him by now. A gray-haired man named Colton, union pin on his lapel. "Your Honor," Colton said, "we object. These demands are overbroad, intrusive, and violate Officer Rios's rights as an employee and as a citizen. He will not be surrendering his personal telephone." I looked at him, then at Rios. "This is not a personnel hearing, counsel. This is a criminal courtroom. I have an obligation to ensure the integrity of evidence presented before me. I am issuing a direct order on the record." I slid the release form toward Rios. The pen waited beside it. "Officer," I said, "you will sign this, and you will comply. Now." His eyes flicked to Colton, then back to me. The thumb started tapping again. His pulse was visible in his neck. "No, Your Honor," he said. 2 words, just 2. But they hit that room like a dropped gavel. There is a line in every courtroom where firm disagreement becomes outright defiance. He had just stepped over it. "Let me be absolutely clear," I said, voice low. "You are refusing a lawful order of this court to authorize release of potential evidence in a criminal matter and to produce related recordings under subpoena?" "Yes, Your Honor," he answered, squaring his shoulders. "On advice of counsel." Colton added, "We believe your order exceeds the court's authority." The gallery erupted in whispers. I heard someone mutter, "He can't do that." Another voice, "Watch him." What happened next made the whole courtroom go silent. "Officer Rios," I said, "I am holding you in direct contempt of court. Effective immediately, you are remanded to custody until such time as you choose to comply with this order or this court revises it. Bailiff." You could hear the metallic click of the bailiff's handcuffs from 3 rows back. The sound has a way of sobering people. Rios's face flushed. For the first time, real fear crept into his eyes. He'd put cuffs on countless people. Now they were closing around his wrists. "Your Honor," Miller began. "Sit down, Mr. Miller," I said. "You brought me a case built on the testimony of an officer who just refused to obey a direct order concerning evidence. We are not proceeding another step until this is addressed." The bailiff led Rios to the side door, his steps heavy. The emblem on his shoulder patch flashed once under the fluorescent lights, and then he was gone. That should have been the end of it, but the next detail stopped the room cold. "Your Honor?" The voice came from the gallery. I don't usually entertain voices from the gallery, but something in her tone, sharp, shaking, made me look. It was the young woman with the white knuckles and the tight grip on her phone, Jamal's sister. "Ma'am," I said, "you do not speak from the gallery. Sit down, please." She swallowed. I'm sorry, Your Honor, but I have the video." The entire courtroom turned as one. Ruiz's head snapped around. Miller's eyes widened. "Approach the podium," I said carefully. Slowly. She walked forward, phone trembling in her hand. "What's your name?" I asked. "Taylor Harris, Your Honor. I'm Jamal's sister." "And what video are you referring to, Ms. Harris?" "The stop," she said. "I was on a video call with him when the officer pulled him over. I didn't know if it mattered. I didn't know what to do with it." Cameras in a courtroom are complicated things, but this wasn't a camera in the courtroom. It was evidence from outside it. We took a brief recess. The clerk, the lawyers, and I huddled around a monitor in chambers while IT mirrored Taylor's phone to a larger screen, preserving a copy. The video was shaky, vertical, grainy. Jamal's face filled most of the frame, lit by the dashboard. "You still there, Tay?" his voice said. "Yeah, I'm here," her voice echoed faintly. "What happened?" "Got pulled over. Taillight, I guess." The screen shifted as he angled the phone slightly, just enough that we could see the officer's approach in the corner of the frame. Rios. We watched as he came to the window, hand already resting on his weapon. His words were muffled, but his tone was clear. Sharp, commanding, almost aggressive from the first second. "Step out of the car," he said. "For what?" Jamal asked. I said, "Step out of the car." There was no explanation. No, "You're being detained." No, "Here's what I smelled." Just command piled on command. Jamal set the phone down in the cup holder, still recording. The angle wasn't perfect, but it caught enough. He stepped out, hands visible. "Turn around," Rios ordered. Jamal turned, hands still up, and then, without warning, Rios grabbed his arm, yanked hard, and swept his legs. Jamal hit the asphalt with a dull thud, a groan escaping. From the speaker, Taylor's voice cried, "Jamal! Jamal!" At no point in that entire 30 seconds did Jamal move toward Rios's weapon. Not a lunge, not a grab, not even a step in that direction. We watched in silence. When the clip ended, I felt something I rarely allow myself on the bench: anger. We went back on the record. The video, properly authenticated, was played on the courtroom's main screen. The gallery watched the same seconds we had just watched in chambers. A pin could have dropped and we would have heard it. When it ended, I turned to the nearly empty jury box where Rios now sat in cuffs, under guard, pending a contempt hearing. "Officer Rios," I said, "do you still maintain that your incident report is accurate?" His lawyer leaned toward him. They whispered. You could see the options weighing themselves on his face. "Yes, Your Honor," he finally said. "I stand by my report." It was, in that moment, the worst possible answer he could have given. Not because of me, because of what it meant for him. When someone doubles down on a lie after you've just watched the truth in full color on a screen, there is nowhere left for them to hide. That's the moment a courtroom decides who to believe, for this case and every case like it. If you've ever felt that shift watching a trial, where your opinion snaps into place, tell me about it in the comments and hit like so I know these long-form breakdowns are worth your time. Now let me show you exactly how that answer ended his career. First, I addressed the case in front of me. Jamal's case. "Counsel," I said, "approach." We discussed the legal standards, probable cause, material omissions in a report, the impact of concealed evidence. Then I went back on the microphone. "For the record," I said, "the court finds that the body-worn camera log, the vendor's deletion record, and the newly admitted phone recording directly contradict key portions of Officer Rios's incident report. The report states that the defendant lunged toward the officer's firearm. The video does not support that assertion. The court further finds that the state's failure to produce full footage is not attributable to the defense." Miller looked sick. Ruiz looked like she wanted to collapse and cheer at the same time. "Given these findings," I continued, "the motion to dismiss is granted. All charges against Mr. Harris in cause number CR 19482 are hereby dismissed with prejudice." Jamal's shoulders sagged. His sister clasped her hands over her mouth. Tears streaked down her cheeks. But I wasn't done. "Second," I said, turning toward the officer, "the court will be issuing a written order transmitting this transcript, all exhibits, and the vendor records to the district attorney's office, to the Internal Affairs Division of the Riverton Police Department, and to the State Peace Officer Standards and Training Board for review of potential perjury, evidence tampering, and policy violations." Colton started to protest. I raised a hand. "Counsel, he took an oath in this courtroom. If another agency determines he did so falsely, that is their purview. Mine is to protect the integrity of these proceedings." I looked directly at Rios. "Officer, you are a necessary witness in countless other matters. After today, every defense attorney in this county will be entitled to ask a jury, do you trust the word of a man who deleted evidence and refused a lawful court order? You may very well avoid prosecution. Your union may fight for your job, but your credibility, the only real currency you have in this room, is gone." His eyes were wet now, his jaw clenched. For the first time, he seemed to understand what had actually ended. Not his shift, not his day, his usefulness as an officer of the law. I lifted the gavel. "Contempt order stands pending further hearing. We are adjourned." The sound of the gavel echoed through 4B like a closing door. And for him it was. The legal system moves slowly after the drama fades. There are memos, closed-door meetings, quiet resignations. Weeks later, a letter crossed my desk. Internal Affairs had substantiated policy violations, failure to preserve evidence, report inconsistencies. The DA's office had placed him on a Brady list, a disclosure requiring that his history of dishonesty be revealed in any future case where he testified. Not long after that, another letter, this one from the State Post Board, certification revoked. I have seen officers survive use of force complaints, angry op-eds, even criminal indictments. Some deserve to. Not every mistake is malicious. But when an officer lies and hides evidence, it's like driving a spike into the foundation of the courthouse itself. You can't just patch that over. Rios resigned before the formal decertification hearing. On paper, he stepped down. In practice, his career ended the moment he chose defiance over truth in my courtroom. As for Jamal, he walked out that day technically lucky, charges gone, record intact. But I know better than to call it luck when you need a shaky phone video and a stubborn judge just to get back to zero. I've been on this bench long enough to know that no one walks into my courtroom as a pure hero or a cartoon villain. Jamal had made mistakes in his life. So had Rios. So have I. So have you. The difference that morning wasn't about who had priors or who wore the uniform. It was about who moved toward the truth when it finally stepped into the light. Jamal, confronted with the weight of the state, chose to stand there and let the system work, even a system that had failed him before. His sister chose to speak up, even though the gallery is the last place most people want their voice to crack. Rios chose something else. He chose to protect his report instead of his integrity. He chose no when the law asked for yes, and the law answered back. In a way, what happened that day is a dramatized composite of 100 real mornings, small lies growing into big ones, power forgetting who it answers to, and the truth squeezing itself into the record through any opening it can find, even a vertical phone video from a shaking hand. I don't take joy in ending careers. I don't wake up hoping to put cuffs on officers. But I swore an oath before I ever put on this robe. It wasn't to the department. It wasn't to the union. It wasn't to the loudest voice in the gallery. It was to the idea that in this room, everyone answers to something higher than their own story. Sometimes accountability looks like a prison sentence. Sometimes it looks like a quiet dismissal. And sometimes, like it did that Wednesday at 8:43 a.m., it looks like a man in uniform realizing that his badge no longer opens any doors in this building. If there's a lesson in that for any of us, it's this: protect your integrity like it's your only credential, because when the cameras roll, the transcripts print, and the evidence plays, it might be. And remember, these stories I share are dramatized, but the consequences they point to are very, very real. If you're still with me, you've just sat through one of the hardest reversals a courtroom can hold, when the system turns its scrutiny onto the people sworn to uphold it. If you want to see what happens when a forged signature on a single sheet of paper almost sends an innocent teenager to prison for his mother's crime, watch the next story in this playlist. That case didn't just test the law, it tested what a parent is willing to risk when the truth finally shows up.